Well, good afternoon, folks, and thank you for joining us. I would imagine that some of you might watch this video here this evening, and some of you may watch the recording at a later date. But my name is Michael Gault. I'm with the eminent domain team at Bell Carrington, Price and Gregg, and we're here this evening to provide a virtual town hall for some of you that may be interested in the impacts to your property from a portion of the State Route 92 widening project. If you live in the area, you know that various sections of 92 have been widened or improved up and down the state. But we're here today to talk particularly about Project 7692. And this is a section of 92 that transitions from 2 lanes to 4 lanes in Paulding and Cobb counties. The project limits of this project are from just north of State Route 120 to Old Burnt Hickory Road. That's the section that we're talking about here today. This is a section of a project where the initial public input began all the way back in 2013. And now here we are in 2025, and right-of-way authorization has kicked in. We know that right-of-way acquisition, if you haven't been contacted already, there's a good chance that you will likely be contacted soon if you are a landowner of an impacted property. What do we mean by that? Well, naturally, in a project like this, when you take a road that currently exists mostly in 2 lanes and you widen it to the proposed project, which is 4 lanes with a raised concrete median, as that road footprint widens, then private property on both sides of the roadway might need to be acquired in order to complete the project. When the government, in this case GDOT, goes to complete projects like that, they often use what's known as eminent domain to acquire their property. What is that? Well, eminent domain is a fancy phrase that basically means that the government has the right to take private property for a public purpose. That's what we refer to when we talk about the government's right to eminent domain. And in this particular project, there's a high likelihood that many of you will be impacted by eminent domain, and that the state will need to acquire some of your property, in some cases, potentially all of your property, in order to make sure that this widening project can proceed as planned. And that's what our firm, our eminent domain team at our firm, and others like ours that do eminent domain work, that's what we're here to focus on. We schedule these town halls to give you some information about the project, but most importantly, to tell you what the process looks like and how we may be able to help you through it. So let me take just a couple of minutes and let you know what this project or this process typically looks like from start to finish. At the initial acquisition phase of the project, either a GDOT employee or a GDOT agent representative will reach out to you to let you know that your property is likely going to be impacted, that they need to do some studies or some appraisals in order to tell you exactly how much property will be needed. And at some point, they'll make you an offer for that property, that amount of property. What we find is that oftentimes the initial offer that landowners receive doesn't truly represent the actual impact to the property value. And there are a number of reasons behind that I'll hit on in a few minutes. But the landowners usually disagree with the governmental entity about how much they're offered versus how much their property is worth. There can be a time of negotiation, but at some point that time will end. And if the government needs the property, they have the right to file what's known as condemnation, which is essentially a lawsuit filed, in this case, by the Georgia Department of Transportation against a landowner, where they claim and ultimately they take the property that they need to complete the project. That doesn't mean that negotiation is over, and that doesn't mean that you as a landowner won't be compensated, but it does allow the state to proceed with their construction schedule. After that lawsuit is filed, certainly we would recommend that you speak with a licensed attorney to give you some information and to hopefully represent you through that process. It can be a complicated process to handle on your own, certainly can be frustrating, and it can be confusing. And so having adequate representation, especially during the condemnation process, is essential to make sure that your rights aren't violated and that you receive what's known as just compensation at the end of the day. Now, that gets back to the offer and the ultimate settlement amount that we were looking at, and the term is just compensation. Even though the government has the right under the theory of eminent domain to take private property for a public purpose, the law also says that they must pay the landowner fairly and adequately for what is acquired from them. It sounds easy enough. They're going to take my property and they're going to pay me fairly for it. Well, that maybe the tricky part is determining what is true, fair, and accurate just compensation. There's no such thing as a just compensation formula. Oftentimes, the appraiser or the right of way agent would like for you to believe that they just do a simple formula of a comparable sale. They find the square foot value, they do the multiplication times the amount of square foot needed from your property, and they add those two numbers together to give you your value of your property. Oftentimes, they fail to understand or to add in or to offer the damages to the remainder of the property. What I mean by that is they may take a few square feet along the frontage of a residential property, but they fail to consider how that taking may impact the entire property's value, including the home, later on down the road when the homeowner gets ready to sell that property. In a commercial or an industrial impact, they may fail to consider how loss of access or loss of visibility or a significant change in elevation impact the total value of the property. And so the determination of true just compensation is complicated. There's no one size fits all answer. Fortunately, our team of attorneys and staff at Bell Carrington focus primarily on representing landowners in eminent domain cases. And so we see this all day, every day. We focus on calculating true just compensation and determining the impact to a landowner. And that's something that we're well versed in addition to the process and the procedure when it comes to condemnation in eminent domain cases. And so we can take your case and we can tell you exactly what we believe the impact might be, and we can help you negotiate and work through the condemnation process up and until the potential for a jury trial, which is your final right and remedy as a landowner if you're unable to come to an agreement with the Georgia Department of Transportation as to just compensation in your case. Now, a couple of things that I like to guarantee landowners, which is hard to do in a case like this. Number one is we can't make any guarantees about the outcome of your case, but we do offer the opportunity for free, no cost, no obligation consultations. Our team of attorneys and staff are standing by, ready to speak with you. We can, fortunately, through some software that we have with our firm, pull up the impact to your property individually in a matter of minutes during that initial consultation call. We can tell you what we think and what we're showing that the impact to your property might be, and if it looks like a good fit for our firm, if we believe that we can help you. So that guarantee is no cost, no obligation consultations. We look forward to speaking with you. This is what we do. This is what we enjoy doing. And so even if it's a case that we don't believe is worth your time or that we don't believe that we can be valuable in assisting you, we'll let you know. And no harm, no foul. We're happy to have that conversation with you and at least give you the information that we have in our system so that you can make a more informed decision going forward. The second is that at Bell Carrington in our eminent domain practice group, we have a unique fee structure. It's a contingency fee structure, and that essentially means that we don't ask for any upfront retainer from our clients. They're never charged out of pocket for any costs or expenses, and we don't bill hourly in these cases. Instead, we operate on a contingency fee structure, and our fee is calculated based on a percentage of the amount of just compensation that we're able to recover for our clients. Those percentages can vary depending on the complexity of the case and the stage of the case. So we invite you to reach out to us so that we can analyze your particular impact. I can tell you if I think your property is impacted, how it's impacted, and certainly we can talk more specifically about how that fee structure might operate in your particular file. So again, here to wrap up just briefly, the project, this one is one that's been going on for well over a decade. We're now at the beginning of the end, so to speak. We're working on right-of-way acquisition coming right down the road. Many of you may have already been contacted preliminarily. Some of you will likely be contacted soon. And so we invite you to reach out to our firm so that we can walk you through this process regarding your specific property's impact from start to finish. No cost, no obligation consultations, no upfront fees, no retainer fees, and no hourly fees. Purely contingency with our firm and our eminent domain practice. We look forward to speaking with you so that we may be able to help you. I'm going to enter my information in the chat box, my email, and our eminent domain team's website. At bellcarringtoneminentdomain.com, there's a link in the chat box. You can find a number of ways to reach us. You can call or email us directly, or you can schedule a call through a calendaring app on that website, or you can fill out a form with your information and allow our team to reach you at your convenience. A number of ways there to get in touch with us. We look forward to speaking with you. And on behalf of the Bell Carrington Eminent Domain team, I want to thank you for your time tonight. Michael Gault, look forward to hearing from you and hopefully working with some of you in the future. Thank you.